And so that's regarding any prior convictions. Included in that is the fact that there's an immigration hold against him. There's also an issue regarding how the police got to him.
Oh, no problem. See, you're better than I am because it takes me a long time to try to find it on Odyssey. You know, whoever made Odyssey, if you type someone's name or number in, to me, there should be a search engine where you just say indictment and then there it is.
Oh, there is.
Oh,
Honestly,
what?
there's a way to like look up like.
Get out of town. And I just put in the words indictment and it pops up.
I have to like figure it out. Like,
Oh, wow. See, you are not living unless you learn something new every day. I just learned we can do that. All right. We're going to go on the record in 2023 CR 4371B State versus Marco Antonio Marino Vasquez. We have an interpreter here. If you can raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right, and then for the state
Megan Galloway from state.
and for the defense.
David A. Garcia, attorney for Marco Moreno Vasquez.
All right, and we have an interpreter in training. If you'll state your name for the record.
Guillermo Lozano.
All right, thank you. All right, both parties have agreed to start jury selection tomorrow morning. Is that correct?
That's correct.
That's correct, Judge.
And then that'll give you a chance to maybe get different clothing if you want to. The jurors will be up here. I've asked them to be up here first thing in the morning. They probably won't arrive till 10. So I'm going to ask that everyone be here no later than 10 a.m.
Yes, correct.
All right. And then the court has received an acknowledgement of discovery. Counsel, have you received all discovery and reviewed it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. And then defense, it's the court's understanding that you have motions.
We do, Judge. There's about 9 from defense and several from the state.
Okay.
And the prosecutor and I went through them this morning so that we can sort of make it easier and just put on the record what we're all agreed on.
Okay.
So motion for discovery, we're agreed and everything's been turned over. There's an order in the back.
All right, the court then is signing the order on the motion for discovery, and for the record, the court will note that the defense has stated they've received all that's been requested and the motion for discovery.
Judge, the next one's motion for discovery of punishment evidence. The state agrees to that and they've previously emailed me one. They're going to be handing me one today, which I'm in receipt of.
All right. For the record, the court will note that defense has stated that he has received discovery for any punishment evidence. And the court is signing the motion that it is agreed to.
The next motion, Judge, is motion to require state to reveal agreements. There is a co-defendant who previously pled. The state and I went over it. They are agreeing to this motion and telling me that there are no agreements regarding any witnesses in this case against Marco Moreno.
All right. My pen just died. All right. For the record, the court will note that the state has informed defense counsel that there are no agreements that have been reached between the co-defendant and the state, and the court is signing the order that if something changes with that, state let defense know.
The only thing with that is, so just so the record is clear, there is no agreement that the co-defendant had previously entered into a plea before the court. And so I am going to tender a copy of the admonishment and stipulations to counsel.
So received. Judge, the next motion is the motion for witness list, which is agreed to, and the state has previously provided me one, but they're going to provide me another one this morning
All right.
or this afternoon.
Thank you. And the court will sign the agreed motion for the state to tender a witness list.
I've received that, Judge. The next one is a motion for discovery of exculpatory and mitigating evidence, basically 404B, which they're agreed to, and it's a continuous duty that they understand.
All right, the court will sign the order and note for the record that the state is in agreement and the state is in compliance with any exculpatory and mitigating evidence.
The next one is motion to suppress, Judge. Statements, which we're going to run with the trial because there is a statement to the police that my client gave when he was arrested, which they've transcribed. So that's agreed to, and we're running the motion to suppress any statements with the trial.
All right, so the statement is in Spanish?
Yes, Judge, and it has been transcribed by the certified translators here on the floor. I filed the notice in advance of 45 days prior to trial. And so the state plans to approach the court prior to calling the witness that we would proffer the exhibit through to have a hearing outside the presence of the jury on 3822. And I can also provide you the copy of the transcription.
Yes, if I could have a copy of the transcription, because of course I don't know what's in the transcription, and I don't know if there are certain things that the state has agreed would not be placed before the jury. So we'll just.
And I'll go through that tonight and we'll discuss it tomorrow morning before they proffer it.
All right, so let me let you keep that
Okay.
because it tends to get.
All right. The next one is a 404B notice, defendant's request for notice of state's intention to use evidence of extraneous offense at trial. And they will approach, it's agreed to, but they will approach if they intend to use anything in their case in chief.
Yes, Judge. So the notice that I filed encompassed any evidence that I would intend to use in case in chief and any punishment regarding impeaching the defendant or any prior conviction that I am in agreement to approaching the court before getting into any.
Okay.
Thank you. Next is the motion to suppress, Judge. They're not intending to induce anything other than statement to my knowledge, but that could change. And so if it does, they're agreeing to come before you before any evidence is offered to the
I'll
jury.
let you hold on to that. Yes.
And then last, Judge, is a motion in limine.
Mhm.
And so that's regarding any prior convictions. Included in that is the fact that there's an immigration hold against him. There's also an issue regarding how the police got to him. It's my understanding that at the crime scene where the murder took place, they were able to look at video and get the license plate of a vehicle. They tracked that vehicle down to the registered owner, who's not my client, and they spoke to him. And in that, he was telling the police something to the effect that he reported the car stolen, that he had contracted with my client to purchase it, to sell it to my client. But at some point, funds were not remitted to this alleged owner. And so he reported it stolen. I've talked to the state about it. I believe they're in agreement that they're not going to introduce that.
Yeah, Judge, so I believe the issue regarding payment possibly could be broached in punishment, but the intention of calling the witness is just to get the agreement and the circumstances and how the defendant ended up with the motor vehicle and guilt.
So we discussed that if they do bring that witness, he needs to be prepared to talk about he sold the car to my client and not go any further regarding an alleged
Theft. Okay. Well, I will tell you, both parties just need to approach and state, just let your witness know.
Yes, Judge.
And I believe that covers all of our motions, Judge.
All right. And state you have motions?
Judge, I have a motion and for me, I'll get it printed for the court, but it's just regarding any wrongs, bad acts, or crimes of the named complainant and the indictment, Danielle Fernandez Valadares, or any other witness that is called by the state, as well as any information to remember to defend under 3914 regarding prior disciplinary actions of any officers with their probation. And it's just that he agrees to approach before he
So what I'm asking is after they finish with their direct of their witness, that they proffer me the NCIC, TCIC, so that I can look at any convictions or
Yes,
bad acts, and then we'll approach and discuss what I can get into.
yes. All right, just approach. And if someone feels like, oh, should I approach on this? Just approach. All right. Anything else?
I think that covers everything.
All right. And has your client done an election of punishment?
He has not, Judge. I was going to talk to him about it, and we'll do that tomorrow.
Well, if we could get it done today.
Okay.
So we'll do the sign in the election of punishment. The court has not made a decision on your case, but everyone who's up for trial, they have to make a decision on if they were found guilty, if they would go to me for punishment or go to the jury for punishment.
So we'll discuss that. You can make your decision. Okay. The one other thing, Judge, is since we're going to have one or two interpreters here, because I understand some of the witnesses speak only Spanish, that the state's bringing, in voir dire, when we speak to the jurors, I'm sure a huge percentage speak Spanish. So do we want to instruct them that they're not to interpret it
They
themselves
always do that.
and let the
Yes.
interpreter make the interpretation?
Yes.
Okay. I think that, because I was going to touch on that, but I didn't want to step on your toe.
Oh, no. I always tell the jurors that whether they speak a language or not, that the interpreter is the official interpreter. And if they think the interpretation is correct, great. If they think it's incorrect, doesn't matter. They go with what the interpreter is stating.
Perfect.
Sure.
All right. Thank you, Judge.
Great. Thank
We'll
you.
make that decision and then I'll see you in the morning.
All right. Thank you.
Thank you.
You're welcome. Oh, Donata. Now, see, Deputy Lord, they haven't done very well with me by Spanish. That's on them. It's the teacher, not the student. But I do know thank you is not Spanish.
She's not a very good student.
They won't even give me an assignment. Where's my homework? All right, who's next?
We have a plea, I just gotta show the back.
Okay. What is happening with McCormick?
Oh, yeah,
Yes.
okay. I received an offer from the state.
Okay. Miss McCormick, come down.
And
I could think.
Hi,
Hi, how are you doing?
I'm okay.
All right, so,
received an offer from the state, Your Honor, and we're still negotiating. I wanted to do a counter offer. State, he says that he's going to look at the videos that I mentioned,
Mhm.
and then in order to perceive it, reconsider what he offered. My client, they found some lumps in her throat
Mhm.
and just went for a biopsy. So she's waiting for the doctor to, she's going to see the doctor pretty soon.
They're
When?
gonna send me to a specialist.
all right, and when is the specialist?
The ear, nose and throat doctor.
No,
but-
I mean, when?
Oh, I'm not sure. They just call us out.
Okay.
And so I'm just asking for, if not, we set it for trial? Is
I
that what
mean,
you
I'll
do?
set it for a plea deadline date, and what I will do
Okay.
is, because you're saying she's seeing a specialist,
Yes, Your Honor.
I'm going to set it for a plea deadline date. And if you find out before then that you all haven't reached an agreement,
Yes,
we can actually do the plea by Zoom.
yes, Your Honor.
All right. So Norma, recall this in 3 weeks for a plea deadline date.
Thank you.
You're welcome.
Could it be after August 3rd, Your Honor?
Sure. Norma, can you put it after August 3rd?
Because I have a trial on August 3rd.
Sure. No problem.
Thank you so much, Judge. I appreciate it.
You're welcome.
Thank you, Your Honor.
All right. Yes, August 10th.
That's good. That's cool.
And Norma, if they reach an agreement, it'll be by Zoom.
Thank you.
All right. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Belzon, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, leave and abandon the punishment.
Any objection?
No objection, Your Honor.
Right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you and your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
We've spoke about this case, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Mm.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is waiving the enhancement allegation. They're asking that your punishment be assessed at 8 months in the state jail facility. There's a $600 fine and no applications. Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is.
State,
Yes, Judge.
did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Your Honor, state offer states exhibit 1 and all attached.
I reviewed it with my client, no objection.
All right, state, you may be excused. Mr. Belzon, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
My client's been telling me that he has attended NA and AA meetings and also
Healthy relationships and anger, and it's a long story. You know, there's too much time to, not enough time to explain it, but I'm tired of being out of jail, and I've been on my own since I was 18, so I just barely started to stay with my sister.
Mhm.
Coincidentally, she started doing the same thing I was doing, so it was kind of a fallback. But she's clean now, and I got work lined up, so I kind of figured I had to do some time anyways, because I was back out there doing what I was doing, same thing, you know. So I just gotta bite the bullet and do what I gotta do. Yeah. But thank you for, you know what I'm saying? Like I told you last time, thank you for been hearing that you've been blessing a lot of people, so you got respect for me.
Well, thank you very much. And I hope you're going to change things, because this is just end up being a cycle, okay?
Yes, ma'am.
All right, the court is going to sentence you to 8 months in the state jail facility, give you credit for any time served. There's a $600 fine, time and money rent concurrent. The court will suggest the therapeutic community. That's to help you with any rehabilitation, but I don't have the jurisdiction to order them to place you in the program. You'll have to ask for it as well. And it is shown on the judgment that I'm requesting the therapeutic community for you. And there's to be no residing in households with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own any weapons or firearms. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. When you're released from custody, the first thing you need to do is find an AA or NA meeting.
But I still gotta deal with parole, so I'm not the, yeah, I'm probably.
No, but when you do parole, because I used to do parole hearings as well.
Oh, yeah.
Yes, when you do parole, what's going to end up happening is they will give you conditions, but they'll also give you resources to help you. So take advantage of that. That's sort of like a safety net, okay?
I didn't do this that time, yes, ma'am. Yeah,
All
and
right.
she lives right by the parole office, so yeah, I just was slacking.
Oh, no, I know it's hard because you have so much temptation, but do right, okay?
Okay, thank you.
You're welcome. Have a good one, okay?
Good.
You're welcome. All right, who's next?